thank you very, very much for having me here this afternoon, and particularly for giving up your Friday afternoon for coming to hear about these new laws that are about to pass in Western Australia. And I have to say, this has got to be one of my most proud moments in terms of doing law and policy in my career, because this is one of the first times when we have truly been able to go, what is it that the most vulnerable in our community need? And I think we've delivered it. So hopefully you'll find the same. Okay, so and also before I begin, I will be going through some things like the restraining order, a bit of the restraining order legislation. So for those of you that are very knowledgeable in that space, I apologise for covering old ground, and I'm certainly not trying to underestimate your expertise, but it's just an important link in the legislation that we're developing. Okay, so we are finishing off in Parliament next week the Residential Tenancies Legislation Amendment Family Violence Bill of 2018. And I know it's a very long title, and you don't need to remember the title of the bill, because once it becomes law, it will simply be part of the Residential Tenancies Act and also the Residential Parks Long Stay Tenants Act. So it will just simply be immersed within those pieces of legislation, and this bill or this Amendment Act will eventually disappear from the statute books. So as we've noted up there, it's amending both the Residential Tenancies Act, that's in relation to all tenancies that are covered by the Residential Tenancies Act. It also amends the Residential Parks Act, but only in relation to what we call on-site rentals. So that's where somebody rents the van and the site that they're on. So if you're familiar with your kind of national lifestyle village type environment, it won't apply to those generally, because in those environments, the resident owns their home and they're only renting the land that they're on. The types of sites that it will apply to are more like your mixed-use caravan parks, where somebody might have rented the caravan and the site that they're living in. And just quickly, I mean, the reason for that is part of this legislation talks about being able to terminate your tenancy with a 7 days notice. And if you've got to move a relocatable home, that's not going to happen in 7 days. So it just isn't practical to extend it across to all tenancies in the residential park space yet. We're thinking about how we can do it in the long term. Okay. It has had a few years gestation. So originally it came out of the Western Australian Law Reform Commission. So our former Attorney General, the Honourable Michael Mission, referred a question to the Law Reform Commission. It was in relation to restraining orders and the Restraining Order Act. And the question was whether we needed to have specific orders relating to family violence. So did we need family violence restraining orders, and did we need legislation specific to family violence restraining orders? In the process of that inquiry, quite a large number of organisations wrote to the Law Reform Commission and said, well, great, while you're fixing up restraining orders, you need to realise there's a problem in the tenancy space. And part of that problem is that currently under tenancy legislation, it is incredibly difficult for a person who's been a victim of family violence to either break their lease, or in a lot of instances, they were finding that magistrates are very reluctant to grant a restraining order that might exclude somebody from the tenancy if their name is on the tenancy agreement, because the magistrates had in mind that it was their premises, particularly if it was only the perpetrator's name on the tenancy agreement and not the victim. And again, I apologise for using language like victim and perpetrators. It's shorthand. I know it's not ideal, but it's just easiest for us to get through the presentation today. Just going back to that review, the Law Reform Commission then made a recommendation that we review the Tenancy Act and its relationship with family violence restraining orders. And I have to say, up until now, Western Australia is the only jurisdiction that has no law in this space. Even the Northern Territory, even Tasmania, everybody else has laws and we don't. So we've definitely taken our wait a while WA slogan to heart on this one. Why do we need it? Again, I'm probably preaching to the converted. You've probably see so much of this in your own work that you do every day. But what the Australian Institute of Health and Welfare tells us is that over 40% of inquiries to homelessness services in Western Australia are from people escaping family violence. So that's just in Western Australia, and in actual raw numbers, that amounted last year to over 10,000 inquiries for help from homelessness services just in WA. We know that in 2016-2017, the police replied or responded to more than 30,000 incidents of family violence in our state. And on average, Australia-wide, there's one domestic homicide a week. In Western Australia last year and in previous years, that average has been once a fortnight. So we actually have half the national average of domestic homicides in our state, and that is devastating, really. Devastating doesn't even come to, it's not even enough. $22 billion is what PricewaterhouseCoopers and KPMG have said we spend nationally a year on the consequences of family violence. So that's the medical treatments, that's loss of jobs, so the social welfare Centrelink support that goes with it, it's the mental health treatments, it's the drug and alcohol, it's the cost of homelessness, it's children having to leave schools and being disconnected from school and family and support networks. So even if people don't want to think about the personal side of it, just purely as taxpayers, we are already paying a huge amount for the consequences of family violence. And that's one of the messages that we've been communicating to landlords, because some of the messaging that's come back to us is, well, why do I as a landlord have to deal with this? Actually, not much from landlords, more from property managers. And we've said you already are. And they already are in their premises in terms of things like property damage and abandoned premises. So these laws will give them a much better way of dealing with that. So just in a snapshot, these is just a quick overview, and then I'm going to go into a bit of detail on all of them. So in a snapshot, where basically the takeaway message from this legislation, it is tenant focused and is victim driven. So the tenant who is the victim of family violence makes the choice. They can choose whether to stay or whether to go. And then any co-tenants that are in the tenancy also get a choice following that incident. Then we're also allowing the court to assign liability for debt and damage arising out of the family violence. One of the things that many of you may see is that when a tenancy ends, all parties are jointly liable for the debt and damage in the tenancy. But what we know in practice is it's often the victim of family violence that takes personal responsibility for that debt and damage to the landlord. And then that is a massive financial burden going forward, when at a time when they're also trying to look for bond and rent to pay in subsequent premises. And often the reason they're carrying that debt forward is because they don't want to be listed on a tenancy database. And also there's a whole lot of shame that is attached to family violence and the consequences of it to others. And so they're the ones that will often in practice carry it. And we know in practice that landlords and property managers have taken advantage of that, and they'll pursue whoever's the most willing to pay. It's not, oh, well, you've paid half, so we'll take we'll pursue the other party for the other half. It doesn't work like that in practice. We're also going to be allowing tenants to change the locks without having to get permission first. The women's refuges in particular are telling us that this takes an inordinate amount of time at the moment trying to get permission from landlords to change a simple thing like changing the locks on the property. They won't need that permission in future. They can just change the locks. It's at their own cost. And I'll go through the detail with that in you. And we're also going to allow tenants to make security upgrades to their premises. So if they're choosing to stay in the rental premises, they can add security to it, a prescribed list, and then that will help make the premises more safe. And then we're also going to be restricting listings of victims of family violence on a tenancy database. So for things like unpaid debt and damage to premises. Okay. Family violence is the definition of family violence is linked to the definition of family violence in the restraining order legislation. The reason we've done this is that we want as seamless as possible connection between those two pieces of legislation. So in the Restraining Order Act, it's a reference to violence or a threat of violence by a person towards a family member or any other person that coerces or controls the family member. Importantly, we need to take a very broad definition of family, okay? And just for people, these slides are up on our department website, so you can access the slides there. I can see a lot of cameras taking photos, you don't need to worry. Okay, so your traditional concepts of people that are married or were married to each other de facto or were de facto, and the child that lives with one of them. But we're also looking at someone who's a guardian of a child. Also, when you come here, the other personal relationship one is really important because that extends it beyond. So we're not talking intimate partner violence, we're talking extended family violence. And in particular, family, I'll be on the next slide, but family is as long as the person believes that these people, that they are in a family relationship together. So it doesn't require that kind of DNA connection that an Anglo-Saxon kind of concept of family. Okay, it's very much a cultural and community concept of family. So we're also looking at domestic relationships where the lives of the parties are very directly intertwined. So in that instance, you can also look at carers, so people who are caring either for elderly people, people who are caring for people with disability, so where their life is very much dependent on the work and the decisions and the conduct of the other party. I want you to think elder abuse is very much covered by this legislation, and yeah, carers and so forth. Sorry, just wanting to make sure. So yeah, in terms of cultural, social and religious connections of family. Okay, so please think broadly when you're thinking family. Also in the legislation, it talks about, so if you have a couple who are together now and one of those parties has an ex-partner somewhere else and that ex-partner is assaulting or threatening the new partner, then that also constitutes family violence. So it can skip over former connections as long as there is a chain of connection along the way. Okay. So from the Family Violence or the Restraining Order Act, they give Section 5A gives you these examples of what is family violence. So again, apologies for those of you that are very familiar with this, but obviously it's assault and sexual assault or sexually abusive behaviour. Stalking is an important one for you to think about in terms of these tenancy laws because the perpetrator does not have to be living in the premises for these laws to apply. So if you have someone who is in a rental property and they are being stalked by somebody who's outside the premises or, you know, from outside the premises, that is sufficient for them to use these laws to terminate their tenancy agreement in order to move. One example we were given in our consultation when I had met with the Sexual Assault Resource Centre. They were telling me about a woman who had moved, so she'd done all the things that we ask victims of family violence to do. So she'd left her partner and had set herself up in a new tenancy agreement and for all intents and purposes had separated from that time in her life, only to come home one day to find that he'd broken into the property and he held her captive and did all sorts of horrible things to her for about 4 days straight. So SARC came into contact with her when she was rushed to hospital because she was very seriously injured. And it took about 4 months for the landlord to release her from her tenancy. Now, psychologically, she was never going back to that property, not alone for which the police went back to conduct their investigations after she'd been taken to hospital to find him hiding in the house waiting for her to come home. And the landlord and the property manager just didn't get that. So he wasn't a tenant. He didn't live there. He didn't have any rights to be there. He'd broken in. Under these new laws, she would have the right to terminate that tenancy in 7 days and just move. She was couch surfing for 4 months instead. Yeah. It was an ex-partner. So it needs to still fall in within that family context, but and I'll defer to the restraining order experts in the room, but if you've got somebody who's envisaging there's a romantic relationship between the parties, if one of them believes that that would be the case, then I would be arguing that that is sufficient. So damaging and destroying family members' property, causing death or injury to the family member's animal, and again, that's another important one. You'll see when we come up some of the factors that we've asked the court to take into consideration when an application is made to have the perpetrator removed from the tenancy agreement is that the court take into account if there are pets in the premises, because if there are pets, it's often very, very hard to move to future premises, because you can't always get another landlord who's willing to take on the pets. So if there's pets present in the premises, that the victim and it's part of their family and their support network, a very important part, then that's something the courts will take into consideration. Denying financial autonomy. This is a very important one, because we know now, very much so, that family violence is not just about the physical assault and sexual assault. Financial abuse is a very important and a very significant part of family violence. In elder abuse, it's probably one of the most significant aspects of it. So it very much falls in. You may find that if you have older clients who fall into that elder abuse category, they may not recognise it as family violence, but you can reassure them that it is, and it falls within this definition. So the other things: preventing social connections, kidnapping, deprivation of liberty, the intimate personal images and exposing children to these behaviours. So that's another important part of this legislation too, is that it doesn't have to be the adult tenant who's been the victim of family violence. If it's the children, then that, and they're dependents of the tenant, then that also qualifies. So if you have a child who's been, say, sexually abused by a relative, by a family member who lives nearby, and you've got Child Protective Services saying you need to move or we're going to take these children from you, this is sufficient for you for your clients to be using this legislation to change tenancies. Okay, so this is if the victim tenant wants to leave. What they need to do is give the lessor a notice of termination. That's it. There's no court. It's just a notice of termination, and then there's a document that goes with it. That notice of termination is 7 days, a minimum of 7 days. You can give them more notice if you want to, but it's a minimum of 7 days notice. Then it must be accompanied by one of the following. So a domestic violence order, and that is defined broadly. So that includes interstate orders, some international orders. It does also include police orders, but they're usually only for a few days, valid for a few days. So it's unlikely that we'd be seeing those being attached, but you might if it's relevant. A family court injunction or an application for a family court injunction, a copy of a prosecution notice. So this relates to a crime committed against the tenant, that is a family violence related crime by the alleged perpetrator. So, but the victim of that crime has to be your tenant. Again, it's not something that we expect to see a lot of in terms of this notice, but we've put it there. And then the other one is a report of family violence in a form approved by the Commissioner for Consumer Protection. And that is a screenshot of what the form is going to sort of look like. It's currently in web development. It will be an online form. It'll be able to be filled in by the prescribed professionals and by the tenant, and then it can be sent in with the notice. So in the legislation, the people who can sign the form is a doctor, a psychologist, social worker, police officer, a person in charge of a women's refuge. So I know on the slide it says manager, but they don't have to be called manager because we know you've all got different names. It was just a bit too hard for us to fit in person in charge of a women's refuge on the slide. And then we've got prescribed persons. So the regulations are being developed now, but the regulations that that we have developed and we have approval to develop include, so we're going to have child protection workers are going to be prescribed, family support workers. So they're the agencies that are funded by Department of Communities to do that intensive in-home support for families, and then also persons in charge of Aboriginal health, welfare and legal services will be the third category of practitioners prescribed. Now, there were very different opinions about having lawyers prescribed for these purposes, and there were lawyers in favour of it and there were lawyers against it, and then there were community people in favour of it and community people against it. So we've gone the safe route at the moment and we've not prescribed practitioners, but it is something that it can be done in the regulation. So as we go along, if you're finding that it's very difficult for your clients to find somebody in one of these other categories that they've had contact with, because the idea that we're looking for here is that we want to stop victims having to retell their story multiple times over. Okay, we've tried to pick the broadest range of categories that we can so that These are people that your clients will already have had contact with and that they feel comfortable dealing with. And all it is the form is the tenant fills in the first half and says, they make a declaration, they sign it to say, yes, I swear that what I've told this person, this professional, is the truth. And then the professional, whichever category they're in, says, yep, according to my professional opinion, this person is a victim of family violence, or this person has experienced family violence. So it's just your professional opinion. You have to be someone that's worked with the tenant, but worked with could be the first time you see them in a 5-minute appointment, as long as you feel comfortable. If you don't feel comfortable signing it, you don't sign it. It's as simple as that. If you're a social worker or a psychologist, you don't have to work for a specific organisation, as long as that is your background, as long as that is your professional qualification, you're good to sign. Okay, so the tenant gives the notice, termination notice, and that form, whichever form they're using, so the restraining order or the professionally signed form, to the landlord, and their liability ceases at the end of the notice period. So, as I said, it's a minimum of 7 days. They could give longer if they want to, but what we're suggesting to a lot of support workers out in the community is think about the timing of giving the notice, because if your client has already fled the premises, that's fine. They don't have to give the notice straight away, but they will. If they don't give the notice, then they're still liable for paying rent. But if they need time to get things out of the house safely, then you might want to factor that in. But having said that, you can still terminate the notice and then arrange with the police to have a time and the landlord to have a time to go in later to pick up their stuff. It'll just be a judgment call. But you do want to make sure they've got a safety plan in place, because once that notice is given to the landlord has to give a copy of the termination notice, not the evidence, so not the form that came with it, but just a termination notice to all the other co-tenants that are in the tenancy, and that may include the perpetrator. So we want to make sure that our clients have got safety plans in place before they give the termination notice to the landlord.
Sorry.
Yeah.
Yeah. So with that, they give them 7 days notice, but the landlord then needs to notify the others straight away. They don't have to wait 7 days to notify.
They've got to notify the other co-tenants within 7 days.
Within 7 days.
Of having received the notice. Yep. And then the co-tenants have 7 days themselves to decide what they want to do. And then if they want to stay, that's great. They stay. The landlord doesn't get to say you're out. If they want to leave, they can then give notice, and their notice is 21 days. And that's even if it's a fixed-term tenancy. So it can bring a fixed-term tenancy to a conclusion. And that we found is really important, because there is no point. If you've taken one person out of that tenancy equation who was paying a share of the rent, and the remaining tenants can't afford it anymore, why set everybody up to fail at that point and make them stick to a fixed-term tenancy that's only going to end in a lot of pain 3 or 4 months down the track when everybody's in court getting the tenancy agreement terminated and rent owed to them. So we're forcing parties to have a conversation at that point and then to decide which way they want to go forward. Now, the landlord cannot say, you're a perpetrator of family violence, I don't want you living in my tenancy anymore. It's not up to them on that. And we've made that really clear, and we've explained to landlords that it's actually very dangerous. If we start going evicting all these perpetrators, it just increases the danger levels for the victims exponentially, because the perpetrator is likely to blame the victim tenant for them having lost their tenancy, and that then adds pressure onto that situation. It's also going to force a lot of victim tenants to really second guess whether they're going to leave or not. If they know that they're going to impact on the tenancy and the right to live somewhere for the rest of their co-tenants, then we find that makes them sit back and not take that out that they need to keep themselves safe. So once the co-tenants give notice, theirs is 21 days. If you've got more than one co-tenant, you might have 2 or 3. It might have been a share house. Some might decide to leave, some might decide to stay, and that's fine. Okay. If they want to bring in more other people, then that is up to the landlord to say yes or no to that one. But if they themselves are staying, then the tenancy agreement continues on its ordinary path. Okay. So there's going to be times when the victim tenant wants to stay in the property. And often that will be if they've got children in a school and so they want to keep their children safe and located. Sometimes it'll be if they've got older children, because a lot of women's refuges, particularly if they've got older sons, because a lot of women's refuges can't take boys over the age of 12. And so if you leave and you have to go to a refuge, it means having to farm your older boys out to other family members or friends, so breaking up that family unit. Often there can be no space in a refuge, so people are worried about becoming homeless. They might have work and things like that, and they might have really good support networks in the community and they want to stay put. And we're giving them that choice. So again, this is their choice. But because they're affecting or potentially affecting the right to live somewhere of somebody, of a third party, this is a court application. So the tenant has to apply to the court to have the perpetrator's interest in the tenancy agreement terminated on the grounds of family violence. It's at the moment, it'll be a Form 12 that the tenants use, for those of you who are in tenancy space. But the Magistrates Court are in the process of amending all of their tenancy application forms. So, but for now, it'll be just the normal form that somebody fills in to get an order from the court. And the lessor and any co-tenants are respondents to that court application. So the court sends that notice out to all the parties. So they all get to come and they all get to be heard on that application. So these are the factors that we've told the court that they have to take into account. The best interests of any child ordinarily resident at the premises is the paramount consideration. So there's a clause in there that says that one is number one, no matter what. Then the rest of them don't have any kind of order of priority. It'll be up to the magistrate. We've looked at the best interests of the protected tenant, being the victim. If they're in a social housing, so if they're in a Department of Housing tenancy, so a subsidised rental, and they want to be able to stay and have the perpetrator removed, then that's very high in the order of priorities for the court to consider, because to force the victim tenant to have to move out into the private rental sector is incredibly detrimental to them. We're looking at the effect the order might have on the lessor and any other co-tenants, so the landlord's interests are taken into consideration there, the effect that it might have on any pets that are kept. And this last point here is very important, and we were actually asked to put that in by the Commissioner for Victims of Crime, and it comes out of the restraining order legislation. But sometimes what happens in restraining order, and again, those of you that work in that space will have seen this happen, but sometimes perpetrators will make an application for a restraining order saying that they're the victim and the true victim is the perpetrator. And what we don't want is, or what we want to try to minimise, is the same thing happening in this space. So we don't want a perpetrator coming before a magistrate pretending to be the victim or putting themselves out to be the victim, and to have the genuine victim evicted by the court. So what we've charged the magistrates with doing, and keeping in mind that the magistrates that will be dealing with this matter are tenancy magistrates, so they're not the same magistrates that deal with restraining orders, so this is all quite new space for them. We needed to let them know that they have to ask a lot of questions to make sure that the person before them who's made the application is the genuine victim in that whole scheme. And that might mean looking at police reports and things like that. Now, if the court is satisfied that family violence has occurred, then the court can terminate the perpetrator's interest in the tenancy agreement. The order doesn't take effect for 7 days, and the reason we've given that 7 days grace is in case that last scenario happens and we inadvertently have a victim's interest in a tenancy agreement terminated. We can quickly get them into a tenant advocate, put in an application to the court to have the order set aside and have the matter reheard. So we're just trying to buy some breathing space there to try and protect against worst case scenario. But the order must take effect within 30 days. So 30 days is the maximum outset that it has to happen, but it can't happen before 7 days, just to give that breathing space. Sure.
Have you thought about cases where there's cross applications? When I say that, I mean I've had an application from one party and they've provided the evidence under oath to grant it. They have the other party turn up later on with an application with a different set of evidence which they've given under oath, and been obliged to grant both of them. So you end up with two parties with restraining orders, one of which might have actually lied under oath.
Yeah.
And what do you do? What are you going to do there?
Well, the question was for those that couldn't hear it. It was, have we thought about cross applications? And that's exactly what would be happening in this situation. So you would have perhaps a perpetrator applying, putting themselves up to be the victim, having a victim terminated from the tenancy agreement. The victim then applies to have that order set aside and have the matter brought back to the court. Magistrates see this all the time. It's up to them to have to determine what is the most likely truth of the scenario. Now, they have to be satisfied that family violence has occurred. I met with some of them last week and we talked through, and I asked them what types of evidence they would like to see coming in from applicants in order to satisfy them. Again, bearing in mind it's not restraining order court. So if there is a restraining order in place, then this is just that just takes place. You can apply to the court with the restraining order and they'll take judicial notice of that. Yes, but they would take judicial notice of the fact that it's an interim order. So they would probably want a bit more than that. They need to be satisfied as well. That it's not, because they'll be aware that the interim order is generally ex parte, and so they'll want to do a little bit more inquisition of the parties, a little bit more questioning, and probably want some other evidence before them, or at least the evidence that came before the court for the ex parte application. It'll be a case-by-case basis, so because we haven't prescribed any evidence that is to come before the court. The family violence form that I showed you earlier, which is to terminate your tenancy, that's not needed in this application, but you could use the same kinds of professionals to prepare a report for the applicant to use. And I said to them, do you want the professionals in front of you or are you going to take the report? And they said, by and large, they'll take the report. As long as what they're not getting is the traditional doctor's sick note that says this person's unfit for work, when in fact it's a court hearing and stuff. They want a bit of detail in it and they'll accept that as being evidence. But if your clients have had contact with the women's refuges, then by all means have the refuge prepare a report or come along to give evidence. Medical, they said hospital admissions or emergency room reports, police reports is particularly helpful of call-outs that they've done. And one of the things we're going to be talking to the police about, hopefully, is how we can facilitate that evidence being released really quickly, because it's an automatic process under restraining order legislation. It won't be automatically tabled in these tenancy applications. So we're trying to avoid having to go down the freedom of information path. So I'll keep everybody posted on that one and how that happens. Just keep a look at our website. Yep.
Sorry, Trish, I was just going to ask in terms of getting some of that relevant information that's on the system. I thought about the civil magistrates accessing that to determine whether it's family violence or not. Will they be able to, off their own back, sort of look at information like criminal records and restraining order history?
Yeah, the magistrates are entitled to inform themselves any way they think fit under the Residential Tenancies Act. They have this lovely power that says you can inform yourself however you want to. So if they want to make their own inquiries from other parts of the court, then they can absolutely do that.
So any part of your discussion with them, do you get a sense they were happy to utilise that?
It's a suggestion I'm happy to put forward to them now. Because the staff themselves, the court staff, are trying to work out how they're going to facilitate this information and work this through for the magistrates so that the magistrate's life is easier as well. So I'll put that forward and suggest that whatever's around in the other courts might be brought forward. Yep.
Is there a proposed turnaround time between an application being made where you've got cross BROs by the time you get to court and that issue is dealt with? No,
so there's no time frame on these applications. So, but the court is mindful that they want to deal with these ones quickly, so they will be trying to fast track them through. But having said that, they're mindful they need to have a balance of interests of all the parties. So if they rush it through too much, then you have the respondent tenant and the landlord going, hang on, we haven't had a chance to prepare our case and put our arguments forward. And if it's left too long, then we're potentially leaving victims in danger. Bearing in mind that the kind of people that are going to be making the applications to stay are people who feel quite comfortable and safe where they are. So it's very likely that they will already have a restraining order that has exclusion orders on it so that the perpetrator can't come forward and can't come to the premises under the restraining order. It doesn't have to be the case, but it would, or that the perpetrator has already moved on and they just want to make it final. One thing we're making very clear to tenants and to tenant support workers, and it's really important to know, is that this is not a substitute for a restraining order. So you could get the perpetrator's name removed from the tenancy agreement, and if they come back to the premises, it is just trespass. It is not a breach of a restraining order under this law. This is just civil tenancy law. It doesn't have any exclusion powers beyond you excluding the postman or, anyone else, any stranger that walks up to the door. So we need to be really careful about that. If we're advising people that they're going to do this, we strongly encourage them to also have the restraining order in place so that, because yes, the police will respond if they get a call out and family violence has occurred, but it'll be a different priority of response to if there is a breach of a restraining order happening. So we need to be careful around that. But there's no timeframes on this, and the court, this is all going to be very new for tenancy court, so it will be a matter of us kind of muddling through for a little while and seeing how it all works. Any more questions on this one?
So what happens if there's an order in place that hasn't been made final, you've got a magistrate in this jurisdiction making a decision, how is that not going to affect the outcome of the final order hearing? Because essentially a magistrate in the criminal jurisdiction, or the VRO jurisdiction, is going to be saying, okay, we've already got a magistrate that's tested this evidence in a sense.
It's because they're different burdens of proof. So this one is your civil jurisdiction, so it's just balance probabilities.
But you're saying that the task for these magistrates is still going to be an onerous one. They have to sort of really be diligent.
They do, but not to the same level as you would be if you were issuing a restraining order, which is going to be severely curtailing the liberties of a person in terms of where they can and can't go and who they can and can't have. I think a magistrate would have a different burden, like a different hurdle to a bar to cross for a restraining order than they will for the tenancy. It will still be high, but not as high as a restraining order. So the restraining order magistrates will not be bound by a decision that's been made in the tenancy court at all. Yep.
Okay. Where you have a couple, married or de facto with children, who perhaps are not perfect parents by a long way, and there's a lot of separation, instigated violence between them, they split up. One then applies to this court to have the other one evicted from the tenancy, purely really for the purpose of retaining the children and gaining a benefit in the sense of stability insofar as that would carry weight in the family court. I'm just thinking of the time frame of this and how quickly this would go through, because for the parent who was the defendant to that application, for them to make an application to the family court for an order, and leaving aside their right to make an application for a restraining order, but for them to make an application to the family court could take them now a significant amount of time to get before a magistrate. For all the court does its best to expedite urgent family law matters that relate to children, because of the demands on the family court, that doesn't always occur. What would concern me is the time frame, if you like, and how quickly this application might be put in, how quickly it might be heard, and how disadvantaged that defendant to that application might be, and assuming that perhaps there have been a similar level of violence, as unfortunately there sometimes is in the drug-related matters, just how that time frame would pan out, taking into account the difficulties in getting a matter now, even an urgent matter, in front of a magistrate in the family court. I guess that's my query. And leaving aside the possibility of going and getting a restraining order as a protection.
Sure. The short answer is, unfortunately, there won't be a connection between the two timeframes. The court is endeavouring to be as mindful as possible to expedite these types of matters through. Now, when we say expediting, in tenancy world, that is probably less than 12 weeks. That's kind of, the average for an application in tenancy. Look, sometimes it can come up before the magistrate within 2 to 3 weeks. Sometimes it can take up to 12 weeks to happen. There's no, and it varies a great deal from court to court, but I certainly wouldn't see it happening any later than that rough time frame. In terms of that scenario where you have children involved, and bringing you back to that best interests of the children that are ordinarily resident, then one of the questions that I imagine very much so the magistrate will have to turn their mind to is who is the primary caregiver of those children. And I know that that's not always an easy answer to do. And this is not a perfect science, unfortunately. And unfortunately, in this legislation, we know that there are people that are also going to manipulate the system to their advantage. We've tried to mitigate against that as much as possible, but our driving consideration by and large has been not to make it so difficult that it doesn't work for the people who desperately, genuinely need it to get out of their tenancies. So if you look at the second reading speech in Hansard, the minister has even said, yes, people will use it just to get out of their tenancy. We know that. There'll be a small portion of people that will. But they were very much driven by the fact that this is tenant-focused, victim-focused, and wanting it to work for as many genuine victims of family violence as possible. So, look, I know it will be another tool in that family court scenario that people will use. But I would suggest perhaps no more than they already are using restraining orders in the ex parte applications and things like that. It will be in that similar, and probably would take a little bit longer than an ex parte application would in a restraining order, but it will be there. The one thing is that these matters should never be heard ex parte. Okay, so the landlord and all the parties, all the co-tenants will be listed on the tenancy, on the court application, and they will all be heard by the court. Now, that's if they turn up for their hearing. And one of the things that we're doing in the department, because filling in the forms is not always easy, and getting people to put in the right names of the right people is a challenge. But we're going to put some fact sheets together to guide people through that. And as I said earlier, the Magistrates Court are in the process of amending their forms, and they're going to have just one form for tenancy instead of the current 2 forms. And it'll be an online form, and you can say, I need to add more respondents to it. Because at the moment you basically have one applicant, one respondent kind of box in a handwritten form, which doesn't help. So we're trying to make it as user-friendly as possible. So we'll try and make sure as much as possible that we'll get everybody heard. What I can say is in tenancy matters, we're giving that 7-day delay so that an applicant can apply to the court to have that order set aside. That power to have an order set aside is not limited and is not related specifically to these provisions. It is a much broader provision in the Residential Tenancies Act to apply to the court. So if you had somebody who was caught up by that and inadvertently affected by that, then they could at any stage apply, and they weren't properly heard, or they feel they weren't properly heard, or they didn't know the proceeding was on, they can apply to the court to have that order set aside at some later stage. Any other questions on this one? So the question was what happens if they don't know the location of the other party. What the Tenancy Act allows for now is service by email, and the courts do most of their service now by email because it's cheaper. If they then don't have an email address either, then the court has a role to, you may have seen public notices where they have court lists in the newspaper. That's mostly tenancy matters, and it's mostly where the landlord says, I don't know the other party's address. Okay. In this instance, it'll be the tenant, hopefully. But yes, if it's a if it's a scenario we were talking about earlier where you have somebody who's stalking somebody else and they're not a tenant, you'll not ever be using this anyway, because this provision only applies to have someone who is a named tenant removed from the tenancy agreement. If you have a perpetrator who's living in the house but they're not named on the tenancy agreement, kick them out. Otherwise, because they're not on the tenancy agreement. So it's not that legally binding right to live there. They might take other legal action that claims their equitable rights to live there, but for all intents and purposes, they're not a named tenant. But if they are on the tenancy agreement, then this is how you end their rights on the tenancy. Now, the other issue is, if the perpetrator themselves wants to have their name taken off the tenancy agreement, and that might be if they have got an exclusion order against them in a restraining order and they're told they're not allowed to come to the premises, then they very much may want to come off that tenancy agreement, because whilst their name's on the tenancy agreement, they're liable for rent, they're liable for damage, they're liable for whatever happens at that tenancy. So if rent stops getting paid, the landlord can come after them. So they may want to apply. They have to go through this process of going to court. They don't get to give the notice of termination to the landlord. They have to go to court. And that's part of that accountability that we want perpetrators to have. Okay. Assigning liability for damage and debt. So as I said, everyone in a tenancy agreement is normally jointly liable for debt, sometimes jointly and severally liable for debt and damage from the premises. And so this is going to allow the court to determine which debt is attributable to the family violence, and then they can assign that directly to the perpetrator of the family violence, provided the perpetrator is a tenant of the premises. If the perpetrator was not a tenant of the premises, then they can't assign liability to them, but they can say that the victim tenant isn't liable. Okay, so the victim tenant can still be found not liable for the debt, even if you have someone from outside who's come in as part of the family violence. And so that very much covers off your vicarious liability obligations that we have under the Tenancy Act as well. So the application would be made by so if the victim tenant leaves, the landlord has to come in and do a final inspection of the premises. Once that notice has been received, they've got a short time frame to get in there and make the inspection, and it is deliberately a very short time frame because we know that a lot of damage can be done in a short period of time as retaliation. So we want the landlord to get in there and do a good assessment of the premises and what damage might have occurred and what they might be owed. And then they would give the starting point for any landlord is that all tenants are jointly liable. So they just give a notice to all tenants saying, you guys owe me X amount of dollars, say $1,000. Then it would be up to the victim tenant who's left to say, well, I don't want to be liable for this because that's not my fault. Or it might be that you, like I said before, you've got a share house, so you've got a number of co-tenants, and you have some co-tenants who are completely unrelated to the family violence scenario. They know it was happening between a couple that were in one room, but they're completely unrelated to that. And they also don't want to be liable for the damage that happened because of that family violence. So they could make an application to the court and say, well, I want my liabilities determined by the court. I want you to say what I'm liable for. So that would be an application by one of the tenants to the court. The court at that time looks at we've given the court some guiding principles, and I'm very happy to say that we've managed to get reference to human rights in the legislation there. And so we've told the court to understand that family violence is a fundamental breach of a person's human rights. We've also asked them to understand that carrying the debt forward from family violence is another way of victimising a victim tenant and keeping them, in that financial burden that they carry, and that they very much need to be able to move forward and safely and quickly, and that having this debt is often a barrier to that. The other thing is with vicarious liability, we've instructed the courts to understand that it can often look like a victim tenant has willingly allowed somebody to come into their property, and we've said it's not always consent, or it's not always, a joyful consent. Sometimes it is about managing the risk. So if you've got someone at the door, it's a lot easier to let them in and try and placate and manage than it is to try and shut the door and say, you have to leave. And then, or it might be that they are, yes, come in, have dinner with us and the kids, expecting it just to be dinner and the kid, with them and the kids, not giving them permission to then run, and wreck the property and to create damage while they're there. So those are all the messages that the court has to take into consideration when they're deciding to assign liability. Now, it's only family violence-related debt and damage, so the list of damage that the landlord might give to the court might be quite extensive, and some of it might be that, there's crayon drawings on the wall, or there's red wine spilt on the carpet or something, which doesn't appear to be family violence-related. But then you've got, holes in walls and damage to doors and things like and broken windows, which does look like it's family violence related. You might have unpaid rent. And that's where we differentiate from the other states, because a number of other states have this provision, but they only relate to damage to the premises. But we've extended it to unpaid rent as well, because we've said, well, sometimes withholding finances to pay for necessities of life is a part of family violence. So if the tenant can give evidence that they've had money withheld from them, or, you know, say the perpetrator's got a gambling addiction and has used all the money and there was no money for rent, then that debt can get assigned as well. It will allow the court to release part of the bond, so that if the victim tenant is then found not to owe money to the landlord, they can get a pro rata share of the bond back. And the Act defines that everybody has a pro rata share of the security bond, because what we didn't want the courts getting caught up in is people saying, well, I paid all of the bond, yeah, but I paid the 2 weeks rent in advance and I've done this and I've done that. So the starting point is pro rata share of the bond, unless there's strong evidence to the contrary. So if your client has paid everything, so all the bond, all the rent, everything for the property, then you would lead that evidence, and then that might entitle them to get more than just a pro rata share of the bond back. It will also allow the landlord to get paid out bond for any damage that's happened to the premises to date. So it kind of just puts a line in the sand on the liabilities of the tenancy at that point, and then moving forward, whoever remains in the tenancy is liable going forward. The landlord, if there are co-tenants staying in the property, then the landlord can ask the remaining co-tenants to re-top up the bond at that point in time. If the application is made to the court to have the perpetrator removed, there's no need for a separate application to get the liabilities determined. That's an automatic process of that application to the court. Changing locks, it's a pretty straightforward one. So you can change the locks without having to get permission. And so we've had landlords and property managers say, well, don't they have to give us evidence that family violence has occurred? And we've said no, because that defeats the purpose of this quick remedy, because it's intended to be a very quick response to improve the safety of the tenant in the premises. So it's a quick change of locks. If it's in a strata property, you can't actually change the outside parts of the lock, because the outside of the front door and the front lock is actually part of the common property, not part of the premises. But you can change the barrel on the inside. So we're going to have a fact sheet for tenants that are living in strata premises, so that we can go through with them what they can do. The other thing with strata properties, and that the commons space, so the external gates and key fobs you might have for those types of, the entry gates and things like that, that's not part of changing a lock. So a tenant can't change a lock of that common area. But what we're going to do is have a fact sheet as well for the strata companies to give them tips on how they can contribute and be good corporate citizens and do the right thing, which is things like decode the perpetrator's key fob as quickly as they're notified. Now, the tenant when they change the key, they have to give a copy of the key to the landlord within 7 days, unless the landlord is the perpetrator. And the reason we've put that in is that some family law practitioners that were working with us during the development of the legislation told us that they're seeing an emerging trend where in the family court, where the owner of the house is excluded from the premises and their partner and the children are allowed to remain in the matrimonial premises, that it's being declared by the excluded partner as a tenancy, and they're charging their ex-partner rent to live there in the family home. Now, I don't think that's a tenancy. I don't think it forms under the definition, but just to make it clear, if the landlord is the perpetrator, you do not have to give them a copy of the key. But it might also happen in a family situation. So if you've got an extended family member who's leasing property to you, so you might have someone renting to their grandparents or something, and if they're the perpetrator of the violence, the grandparents don't have to give a copy of the key to them. Now, the tenant can then notify the landlord in writing who not to give the key to, and then the landlord is prohibited from giving a copy of that key to whoever they're notified in writing not to give the key to. Security upgrades. So we're allowing tenants to do security upgrades as well, so if they're staying in the home. So the prescribed security upgrades are going to be things like window shutters, window screens and locks on windows, security doors on front doors, external lighting, locks on gates, and pruning of shrubs and trees so that you don't have those hidden spots around the premises. So those are the sorts of things that will be allowed to be done. The tenant bears the cost of them, but there are a number of programs. Well, there's Safe at Home and there's some other community organisations that will do these sorts of changes. Also, includes CCTV cameras and alarm systems on the house. If it's electrical work, it must be done by a qualified tradesperson, and some security upgrades, some security screens and stuff have to be installed by licensed security workers. So if that's the requirement, that's what has to be done. They have to comply with strata laws and have regard to the age and character of the house. And then if the landlord wants the tenant to, they have to restore the premises at the end of the rental. I'm thinking it's not likely that most landlords are going to want these security measures taken off their homes because it makes their homes better. The reason we've put this in, that tenants can do this of their own accord, is the Victorian Royal Commission into Family Violence surprisingly found a large number of landlords, when they were asked if they could have CCTV cameras installed, said no. It's just this automatic response of no, you're not doing it on my property. So we've said, and they recommended that power to say no be taken away. So that's what we've done in this instance. There were changes made to the bill in the Legislative Council, and those changes mean that the tenant, when they get the tradesperson to do the work and they get an invoice, have to give a copy of the invoice to the landlord. And that would be mostly so that if there is any warranty work that needs to be done at a later stage or any issues with insurance, the landlord at least has some evidence that it's been done by a qualified tradesperson and who did the work to the premises. Just at the end, the tenancy databases. So at the moment, there's laws in the Tenancy Act that restrict who and when someone can be listed on a tenancy database. So those of you that aren't familiar with tenancy databases, they're kind of what people colloquially call a blacklist. So it used to be that they weren't regulated at all, and tenants could get listed on a tenancy database by a landlord, and if they were listed, they might be listed for the rest of their natural life. And then subsequent landlords will look at these tenancy databases, and if you're listed on one, then you've just got Buckley's of getting another tenancy. So back in 2013, there were some amendments put in place that restrict when someone can be listed, who can be listed, and how long they can be listed for. This is a further change to that legislation, to those changes, and because in those provisions, if you had a listing made against you that you thought was unfair in the circumstances, you could apply to the court to have that listing removed. And what this change says to the magistrates is being listed because you were a victim of family violence is unfair. So it just removes all of that doubt. So that will be, again, an application that the tenant can make to the court. But what we are saying to landlords and property managers is just don't list them in the first place. You can list a perpetrator if they've caused damage to the property or if they've left owing more money than the bond, because they're the two limitations on the listing. But if the person is in that scenario because they've been a victim of family violence, then please don't list them in the first place. Okay. So that is our website for the time being, of where we've got all the information about this legislation. This slideshow will be up there. That's where this video will go as well, but it's also, I think, going to go on the Family Law Pathways Network website, so you'll be able to access it from there. In terms of timeframes, hopefully we don't have long to go. We're back in Parliament next week for the Legislative Assembly to consider finally the changes that were made by the Legislative Council. If that goes through on Tuesday, which we're fingers crossed it will, we are aiming for about a mid-April commencement of these new laws, because we already have the regulations ready to go. So that's it in a nutshell. Any questions? So you're right.
Hey, Trish, what training has been given to landlords and stuff like that? Is it the same training as this one here?
Okay, so the question was asked is what training's been given to landlords? So I can tell you property managers have all of last year had compulsory CPD. compulsory professional development on this laws. That was largely around the theme of what is family violence, because we wanted them to recognise that. And then a brief look at these laws. This year they have to do a more intensive, this is the practicalities of how this legislation will work. I've also spoken at the property managers' conferences and things like that. Landlords are getting all of these videos on our website, and we're doing e-bulletins for landlords. So that's and then all of our publications are geared at landlords. Tenancy WA receives some funding from the government, and they're out there training tenant advocates, community workers, doctors, and the kit and caboodle. Hopefully, we'll be getting to the police shortly, so we can train them as well. But yeah.
Sorry, Trish. What is the consequence for landlords if they breach this?
Okay, there's two things that the landlords can be in trouble for. One of those is three things. One is giving the key to someone they've been instructed not to, and there's a very big fine for that. I think it's in the vicinity of $20,000. If they give the family violence report to somebody, or the restraining order to an unauthorised person, then that's a $5,000 fine. And if they're found not to be holding that information in a secure and confidential manner, then that's also a $5,000 fine.
I just want to touch on your violent restraining orders.
Yeah.
The difference between the interim and the final order.
What about your conduct agreements orders? Will the conduct agreement be viewed, because it's on a non-admission basis, as an interim order and therefore it wouldn't hold as much weight? Or will it be held under the Act as it is for the purpose of the Restraining Orders Act, a family violence restraining order, and therefore as if it were a final order?
Yes. Now so the question is around conduct orders, so where parties have agreed to be bound by, it's basically a consent order rather than the court determined, a judicially determined restraining order. And is that considered a restraining order? Yeah, there's a couple of different, we think yes, because under the Restraining Order Act, the definition, it lends itself at some point to being defined as a restraining order for certain purposes. So we're saying yes, for this purpose it would be a restraining order.
So just looking at that and coming from the perspective of the family court rather than restraining orders, I would have some concerns about that, because a number of these basically undertaking agreement deeds are done on a without admission as to need basis. And they're done to resolve matters in circumstances, or we certainly advise them, clients, to do it to resolve matters in circumstances where there is likely to be an acrimonious situation which involves children, where there may be proceedings in the family court in relation to children, and where we're doing our best under the mandate from the family court to try and get everything as amicable as possible and child-focused. So let's get out of the way this particularly unpleasant spat you two just had. And one of you went charging off and got your application in for a restraining order. Let's just say, put it in the past, do it on a without admission as to need basis. Neither of you go within 50 metres of each other or whatever it might be. To you then rely on that to found a potential application to the court to evict a party from a tenancy, particularly if there's a discussion about one party moving out and the other party moving back in, is again a potential, I'd almost say obstruction or potential for an obstruction of the process.
Okay, I think I can allay your concerns, because the restraining order, in that sense, when a conduct order would be used in these proceedings, would be one as an attachment to a termination notice where a tenant was terminating their own interest to a tenancy, so that they're only impacting themselves to leave. Directly impacting themselves, yes, indirectly impacting the tenants that remain, but then those tenants can also choose to leave if they want to. and then it becomes relevant in terms of changing the locks or making security upgrades. In terms of making an application to the court to have a tenant, another person's name removed from the tenancy agreement, we haven't mentioned any evidence at all as being mandatory for the court must terminate if these things happen. None of that sits in that legislation. So it's just the court must be satisfied that family violence has occurred. In terms of those conduct orders, it would be enough for a tenant then to remove themselves from that tenancy agreement, but not enough necessarily of itself to have the other party removed from the tenancy agreement. Any other questions? Yeah.
I'm not quite clear on the key thing with the 7 days, where the landlord is the owner of the property, and you've got to provide a key to him within 7 days. Can I give you an example? I had an application a couple of years back where a young lady had taken out a lease on the place, and the owner, it was an investment property, the owner was the landlord. He kept turning up at about 10 o'clock at night and actually coming into the house with his own key, coming into the bathroom as she was showering and treating her, she said in her description, like he was her dad. And I ended up making an order against him, but I also had to put into it, notwithstanding he could exercise his rights under the Residential Tenancies Act. So how does it work when she could have changed the keys as well, but she'd have to give him a key back in 7 days? I mean, ideally the order's in place, so he's theoretically not supposed to go there.
Sure.
But he wasn't meant to go there in the first place under the Residential Tenancies Act anyway.
Yeah. So this only applies, the changing the locks only applies in the family violence scenario. So it wouldn't help your tenant anyway because there's not that family relationship as defined under the Restraining Order Act necessarily. Yeah. So only... Yeah. So, yeah. And then in which case, as I've said, if the landlord is the perpetrator, you don't have to give him the key. So that's an exemption from it. Yeah.